Bring us up, please. Okay. This is the Board of Equalization. We recognize and support your right to come register your concern and appeal the appraisals that are given. Our duty is to hear both sides and make a determination based upon the facts as we see them. The assessor must assess values at market value on all properties in Bannock County. The appeal process gives the property owner the chance to appeal said value before this board. If for some reason the decision rendered does not meet with your satisfaction, we encourage you to file on an appeal with the State Board of Tax Appeals. You also have the opportunity to find relief through the district courts. It is imperative that you focus on property valuations. This is not to protest your taxes, and we will have the deputy clerk, Nancy Allen, swear those that are going to participate in the hearing in at this time.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Okay, this is a little different. Generally, the way this proceeding goes is that we give 3 minutes to the appellant, then we ask questions. We allow the appraiser 3 minutes, and then we ask questions, and then we allow the appellant 2 more minutes. Because this is unique, I'm going to allow 10 minutes to begin.
Not very good. We tried to make it really short for you.
Please state your name.
My name is Lee Radford. I'm an attorney in Idaho Falls. I've represented Brent Nichols and Gary Ratzlaff for many years. They're local real estate developers here in Pocatello. Been involved in a lot of projects.
You can sit. You don't have to stand.
This is Jason Ma. He is a partner of mine in Boise, who's got a lot of done a lot of property tax work. So I brought him in to help me with it. Just briefly, I wanted to. We're appealing an exemption given to the Department of Health Trust. And we know that's kind of rare to be appealing an exemption, but it is the procedure under Idaho statute to come here before you and talk about it. We believe that the law may have shifted somewhat, and we want you to understand that, and we don't think that's available anymore, and we want to explain why we feel that way. As I see it, there's basically 2 issues, and this is a big story, but I'll try to summarize it very quickly. And I think the 2 questions is just how do we, one is like, how do we feel about free markets and competition? How do we feel about just capitalist head-on-head competition? Number 2 is just how, there's the Idaho statute about this particular exemption and how is it going to be applied. So I want to give a little background on just the competition here and why this is important and how that relates to the exemption. And then I'm going to have Jason talk a little bit about the details of the statute and the exemption. The reason why the free markets and competition are important here is Gary and Brandt own DDC LLC and Diversified Holdings LLC, 2 entities that have owned properties here in Bannock County, and especially some properties right near the hospital. They've been private developers in the private market for many years. Gary's an architect. Brent has owned property and developed some great things around here. They also own some land right next to the hospital that we wanted to develop for a lot of years. It's great healthcare space. It's right there. And we've worked with PMC over the years about that. And with that, they were given, back in 2007 and 2009, they were given some special rights, not only to develop those lands, but PMC agreed with them that they would be given the rights to make the first proposal on any new building that PMC was going to build off campus, and that we'd also be given the right of first refusal to match any other offer. So not only are they private market competitors in this space, but they have a special right to develop any PMC building in the future. But the problem is they want to compete in that market. It's real estate space for healthcare is a big market. They want to compete in that market, but Department of Health Trust has decided they want to be in that market. And it's very hard to compete against a government subsidized entity. It's hard to compete against free property tax. And so that's what brings us here. Like, we want to compete, but we want to compete on an even playing field. PHT is supported by Bannock County by obtaining these exemptions for this space. Now, we know the law may have shifted, but it's just hard to compete against that. And the scope of this, I've prepared just a small demonstrative I hope I can share with you, which gives how much this is. Did I provide that to you? It just shows that
We haven't been accepting any data that wasn't presented 3 days in advance.
Okay, we submitted our, that's good, we presented this, a big document that gives you all the law for it. What I've got here just summarizes what we have in here, and it gives you the numbers. I don't know if you want to know that, or I can just.
I'm okay with that. Yeah, where this is
Okay?
a
present it.
special circumstance.
I understand, I mean, we were trying to get all this as quickly as possible, it's a little hard, so. A bunch of copies.
How do you think we feel? You submitted a 143-page brief.
Yeah. All right, so basically, all this shows, just very simply, is that there's 5 properties at issue. The Portland Medical Center complex, the old Bannock campus here in town, the City Center campus, which is the old Farm Bureau building, and then the Northgate properties. And that adds up to about $60 million in value. And if we got the levy rate right, we tried to get that from Bannock County, that adds up to about $1 million in property tax, which is a pretty big figure. I mean, I don't know the budget like you guys do. I think between Pocatello and Bannock County, you're talking about $70 or $80 million of general property tax going. So if that's right, you know, this exemption means about 1.5% more for every taxpayer in Bannock County. So it's a pretty big figure. We believe this exemption isn't proper. Under the Good Samaritan Evangelical Lutheran case, a business that is operating in a capitalist market just doesn't have this exemption available for it. That case says, you know, under that case, which Jason's going to explain a little bit more, you know, that's not available for a business that's operating in the healthcare space. In today's healthcare market, trying to provide services and make money for that. And if it's not available in that Evangelical Lutheran case, which is a bunch of people trying hard to do the right thing, it's certainly not available to Ardent Health Services. That's one of the largest private healthcare providers in the country. And it's certainly not available where you have a business that is actively trying to restrict competition. Here, Department of Health Trust has not only taken their opportunity to try to develop this property, but they've put a deed restriction on all the property in the Northgate area that says that no other healthcare provider or healthcare building developer can build a space in that area. And that doesn't seem like an entity that is, you know, a charity that is trying to promote the best healthcare in the community. It seems like an entity that's trying to maximize the profits for one hospital. It might make sense to make the most money for the trust, but I'm not sure it makes sense under this exemption, which says that it's not available for companies in that healthcare free market. And it's also not, you know, Evangelical Lutheran, I think, also shows that it's not available where you have an entity trying to participate in the real estate market, but is also giving itself an advantage by getting a property tax exemption against all the other real estate developers. So that's the basic background. I'll turn it over to Jason, if that's all right, just to give you the law. Okay.
So, Mr. Chairman, Commissioners, thank you. Lee and Brent asked me to get involved. I was actually one of the attorneys involved in the Evangelical Lutheran Good Samaritan case from the county commissioners, in front of the county commissioners, Ada County, in front of the Idaho State Board of Tax Appeals, and then District Court, and then obviously then to the Supreme Court. We were able to convince the District Court that even though, because of the modern healthcare kind of refund system through Medicaid and Medicare, that because of the benefit that these Lutherans, the Good Samaritan Society, was providing to the community, not just locally but nationally and even internationally, that they shouldn't be penalized for receiving, government kind of, in that case, subsidies to help pay for, the traumatic brain injury, the elderly people that they put up. They are certainly motivated by, their Lutheran background, their religious background, and their charitable background. And so the charitable property tax exemption was overturned by the Supreme Court. They said no, because of the, bottom line, $3 million or $2 million that they accumulated over 3 years, when kind of the refund equations shift in favor for them in 2013, 14, and 15, that because of that, they weren't charitable organizations, so they overturned it. And so, looking at that, when I got involved and looked at all of this, you're thinking, well, in 3 years, they only accumulated $2 million. And we look at the bottom line here, and it's not the same kind of motivations. And I just started digging deeper. It's like, how did they get an exemption here? And I can see, when it goes back from 2009, when it was first granted, it wasn't until 2014 that the Supreme Court actually kind of changed in the law with the Idaho Youth Ranch case, which we give a lot of background on in our brief. And of course, Evangelical Lutheran case in 2016 that I was involved with, that the previous law that was overturned, the Boise Central case, I can see where kind of the percentages in the, where we have the 77% and 23%, I can kind of see maybe where that, the commissioners then in 2009 could, under the law make a case there, but I just don't see after 2014 that being the case. And so we looked at the 2020 and 2021 applications, and that is what we're working off of. And
I'm going to go ahead and allow you to.
Thank you, Mr. Chairman. And so looking at those, when I was involved, our case was, as the taxpayer, you have to present the evidence to show that you're qualified for an exemption. And truthfully, when I looked at the 2020 application, of course 2021 is just a short form to say, yeah, nothing changed from the last year, that there wasn't the evidence there to show that there was a charitable organization owning the property. And really, we get to under the Idaho Youth Ranch case, and we just look at the application in even 2021, the applicant is the trust, and yet on every single one of those applications, it's a different property owner. And under the Idaho Youth Ranch case, a footnote in that case is just saying that if it's not a property that's owned by a charitable organization, it doesn't qualify. And so just on that fact alone, it doesn't make sense that under the first clause of the statute, looking at the statute, that it doesn't, each one of these properties that we've broken down into these 5 areas, they are not owned by the trust. They're not the title owner of it. And, there's 2 main initial requirements that are meant to be met. And those are the property must belong to a charitable organization, and then the property used exclusively for the purposes which it was organized. And so that first, we don't think that they even make it past that first hurdle, as it were, because we look at it's Pocatello Hospital, LLC, Pocatello Health Services, LLC, PHT Real Estate Holdings, LLC, PHT Health and Medical at Northgate, LLC, and PHT 101 North 7th, LLC, that's the owner of the properties. And yet there's no materials that show that any one of those entities is a charitable organization. And sure, I can see that maybe, and in their 2020 application, there is kind of the argument that they put forth that, I think the actual language they put in there, yes, technically the trust isn't the the owner of that property, but, you know, it is, and I think in the one case, it is the PHT Holdings, which is owned by the trust or controlled by the trust. And frankly, the statute doesn't allow for, either way, I guess, either where a charitable organization owns a subsidy that owns the property, or a charitable organization is part owner of the owner, in this case, really, that owns it. And I think under the way that the Supreme Court has strictly interpreted the statute against the taxpayer, I just don't see that there being, any court, especially the Supreme Court, looking at a case like this and saying that, I think it's a fairly easy case for them, where it just says that there's no evidence here that shows that they are qualified for a tax exemption. And I think that is our basic, argument here. And I think we did supply, a fairly extensive packet there with our memorandum in support of our appeal. And of course, not all 143 pages of it were the appeal. We did include the 2020 and 2021 applications just to illustrate it. But I think that's our main case. And then even, if we get past that and look at the evangelical Lutheran case, that goes into all the factors on charitable exemptions, I think there's a lot of issues there. And then even you get up to then the most recent case, the foundation, the J.R. Simplot Foundation case, which just flat out says, well, if it's just construction on the property, that, no matter what, they could say, yeah, sure, in the future you may be charitable, but right now it's just a construction site. So this year you can't apply. So I think under any of those newer cases under the Supreme Court, that there's a good case can be made that there shouldn't be an exemption here, and that's why we've appeared here, and I appreciate the extra time that you've given us.
Okay. And I know your table really doesn't have anything to be involved with this. Any comments at all? Okay, thank you. Commissioners, questions?
Yes, actually, I read through this and then prepping and discussing it. I have several kind of keys that I need to understand. And as I was going through the case, Community Action Agency, Inc. Versus Board of Equalization of Nez Perce County, the justices actually came back and found a criteria to meet for some of these things. And it states that, first of all, in identifying whether it's charitable, as the justices published, is not restricted in traditional notion of financial relief for the poor, but would encompass a wide variety of services, social, recreational, cultural, psychological, religious, and others. To be classified as charitable, an organization need not provide monetary aid to the needy. It may provide any of a number of services of public benefit. The word charitable, in a legal sense, includes every gift for the general public use, whether it be educational, religious, physical, or social benefit. So as I started reading through your argument and the 20 and 21 short form exemptions, that prima facie evidence that's presented is what we require of all organizations. And the Idaho Code says we shall. It's not that we may, it's we shall. So we have a basis of evidence, and if you meet that evidence, then we're going to allow it to proceed. So your argument, I look at that we're looking at the appeal on the evidence provided by the Health Trust. As while we do have subpoena powers, we don't have the authority for discovery, there's other means. I'd look at our focus as very narrow to the case, or to the information which you're protesting, which would be the long and short form. So I would ask just to maybe help me with some clarifications, because it wasn't seem to be refuted or in there. Do you know that if the Health Trust dissolved, where would those assets go?
So those are all good questions, and I appreciate the quote there. Those were bought, I took those block quotes and put them on each case for the Good Samaritan case, because it's like, we want to say that charity doesn't mean that we're handing out, alms for the poor. I understand that, charity means a lot more, especially under this statute. However, there is, just with the, we learned, I guess, kind of the hard way in that case, even, you know, the kind of the modern way of the way that healthcare happens these days, it's, you know, no matter how, you know, within the case of Good Samaritan, you know, they're always going to be fighting that, no matter how much they try to hand out, you know, free care, they really can't under the Medicaid system. And you know, I don't know enough about the Medicaid system, but because, you know, that they're in that arena, that they have to operate under that arena, so it makes it kind of difficult for them to even do charity, but yet they still try to do charity. And so and forgive me if that, you know, I think that has gone to part of your question, but
Yeah, he also asked about what happens on dissolution.
Oh,
which
and
is also
dissolution,
covered
yes.
in-
Yeah,
in-
who would,
in
because that's
Samaritan.
one of the main tenets is, as the justices came back, there's 6 major aspects that they're looking at in classification
Yeah.
of where would the assets go. The assets, the 23% is the assets of the county. That's actually what that is the county owns that. And so they're managed by the health trust under that agreement. And so I'm curious, is there something that would say different, that 23% would not come back to the county?
And I don't think so. I think out of the 8 factors that, you know, those factors that they developed under the Sunny Ridge case, that really the Supreme Court looked at all of these cases from since that time, that's the easiest factor to make. You know, in everybody's articles, you make sure that your dissolution clause correctly states, because, you know, in every incorporation of every nonprofit you do, you more or less cut and paste the IRC requirements to make sure that you make it. But yeah, either the dissolution is going to go to another, in most cases, another nonprofit operating in kind of the same arena. But here, whether or not where those money goes, it sounds like there's agreement here. I'm not privy to that agreement.
And
But
Good Samaritan, the Supreme Court addressed that. They addressed that factor. That wasn't, you know.
right, and that's, you know, they almost all those cases, sure, that's weighed in favor of the taxpayer, because it's hard to show that it's not. But so you're saying that there may be an
I mean,
agreement
is there something else
there's
that we
here-
have not been
No,
made privy to?
and not that I've seen. So yeah, I would say, yeah, probably that factor sure is in favor of the trust, but I'd say that factor is almost always in favor of the taxpayer.
So then I would start going back, and as you raise points to the free market, as much as I'm a free market capitalist that loves Milton Friedman and others, that's not the issue at hand. We're not here to litigate that aspect or contract law that's been brought to us. The main issue that we would then address is, again, it comes back to the services that they're required to pay for. The evidence that's given to us says no, they're not. The next one, and if you have something contrary to this that you can present as evidence, other than I mean, I have an argument, and I appreciate that, and I agree with some of it. But is there something that says otherwise, that people are required to pay for something?
Well, let me answer
Yeah.
that. I mean, PMC is a market player in the market. That's the biggest exemption here is PMC. You'll see that it's $621,000, that 23% exemption. So the biggest, so if we're just going to focus on the biggest one here, let's look at PMC. PMC is a hospital. It operates like every other hospital. It is, for good or bad, it is the most profitable per capita hospital in the state of Idaho.
Mhm.
It's extremely profitable. And how does it make that money? I don't have all the data on the finances, but you know, from my knowledge, it makes money in the healthcare market like everyone else, and that is generally mostly driven. Medicare is the biggest driver of any hospital. You really can't operate a hospital without Medicare. Medicaid's next, and then you know, you get into the private health insurers. But Medicare, you know, I don't have the data, but I know that it's a big chunk of what they do.
So then a follow-up question, Mr. Chairman. With that, as you've stated, PMC is a hospital, and you stated there's several other names on these short and long forms, and I didn't see any of them that was Portneuf Medical Center that was formerly owned by Legacy Hospital Group. I have not seen, am I mistaken that they applied for a health, or did they apply for an exemption? Because I did not see one in here.
Yeah, let me cover that, Jason. So, I mean, their corporate structure is a little complicated, but not overly complicated. You've got Pocatello Health System, which is a Delaware company, and Pocatello Health System LLC is a Delaware LLC. It's not registered here in Idaho, it's in Delaware, but it's a Delaware LLC. The trust owns 23% of that, has 23% of the stock. The Ardent Health Services has 77% of Portland Health System LLC, Pocatello Health System LLC. Pocatello Health System LLC is then owned entirely, it owns entirely Pocatello Hospital LLC, okay? So you've got, and then Pocatello Hospital LLC is the owner of the hospital building, grounds, operations, and so on, as we understand. So you got three levels. You've got the trust owning 23% of Pocatello Health System LLC, Pocatello Health System LLC owning 100% of Pocatello Hospital LLC. So the owner, like what Jason's referring to, you got to look at the owner of the building, which is Pocatello Hospital LLC, which is not a charity.
Well, but is the hospital which received the exemption? Because my question is because the original hospital, 23% was the county's share. We owned the hospital and moved it into the LLC. So my question is, we're claiming that the hospital, and we're asking that because LLCs, and it gets complicated, and I'm not a lawyer, so I'm trying to understand that. But what I do understand is that I don't see PMC Medical Center asking for an exemption, and I see the hospital in records that does pay taxes. They paid about $2 million in taxes between income tax and other things in this last year. And so I'm curious to see then is if they are not receiving, the argument is not then because the hospital pays taxes. So now it's the holdings that are not owned by the hospital that are owned by the LLC, which is the health trust, which is the county's holdings.
Well, okay, that's great questions. Can I break that into two things?
Sure.
First of all, the county holdings. As I read the articles of incorporation, the dissolution provision is like any others, like the typical one I do for nonprofits, which is that on dissolution, if you have to dissolve one of them, and people rarely do, but if you do, it can't go to any shareholders or anybody else. It's got to go, and this one says it goes to the district court of the county in which the principal office of the corporation is then located. Okay? The county in which the principal, I'm not sure where the principal office is, whether it's in Delaware or here. It's a Delaware company. I don't know where its principal office is. But
Question, just point of information then. Where is the health trust incorporated at?
the health trust, I believe, is it Delaware or, let's see, hold on, I got it right here. Idaho, in this article. So that's the first part of your question on that like the county assets. And I remember the election too, and I'm on,
Yeah.
they were the county assets. I think that's an important concept. That is a critical concept, and I think they are the county's assets. The taxpayers of this county build up that equity in that hospital through hard work and tax paying and commissioners doing their work and a lot of people doing work for a lot of years. They build up those assets to contribute to that hospital. And so they are the county assets. Under the trust formulation, as I understand their organization, the county doesn't get that back necessarily. And I think it kind of has, but I think theoretically, I think you have to think that you should be thinking about it like that. I agree with you. And now the other part of your question was, broke that into two questions. The other one, the 23%. Now this gets a little obscure too, and it took us a little bit to figure it out. And the second page gives you the estimated annual cost of the 23% exemption. And all it does is give the parcel numbers of PMC, Commissioner Toby, PMC, what PMC is, the Pocatello Hospital parcels. And it gives the value assessed. But it's clear that the value assessed is not the full value because they've been given this 23% exemption. So the full value is like $150 million. The value assessed is actually $116 million. But in the document, it makes it clear that that's because that reduction is because of the 23% exemption. So essentially, the 23% exemption has been given on a stock holding instead of a real property holding. So the trust does own 23% of the stock, and they were the county assets. I'm with you, but it's just a stock holding, and no one else gets a tax exemption for stock holding. It has to be. It's got to belong to the. It's got to belong to. It's right in the statute that it belong to. So you have to look at the entity that holds the legal title to the property, and you judge it on that, not by who might own it. if a church owns 5% of, a business, doesn't mean that business gets a 5% reduction in property taxes. And that's exactly what's going on here. So it's a little hard to tease out, but if you look at all the applications, and I think your staff will confirm that 23% is built into all these numbers because of that exemption. And it doesn't flash that right on the front of the GIS. And I think a lot of people don't understand it, but it's clear that under the applications, that's what's happening. Did I fully answer your question?
Yes. We're still, yeah. And so again, this is the first time that we've had one of these come, so we're gonna keep, again, we walked through this. There's 3 other parts that I need, that need to be looked at then in this that I feel is because as we're making a determination of what this group holding LLC, several of them hold, is whether people are required to pay for their assistance. The buildings that are held, the medical building on 11th Street is one of them you've indicated, which the old Bannock County campus is no longer theirs. They don't own it anymore. That's gone. The building itself they do. The parking garage structure they do. Whether they're paid to use that. Whether there's a general public benefit. Whether the income received produces a profit. So Portnoy indicates on their long form that they've donated over $25 million back to the county since the inception in 2014. So the argument then would be is the $621,665 times since 2014 is 7 years. That's $3-point-something million. That obviously is less than what the total givings back to the county would be. The next one would be the dissolution. We've discussed that. Charity work provided, and just not because you've received it in the past means that you automatically received it in the future. So it comes back to the discussion then, as I start looking at this, is what I'm allowed to look at. I'm not looking at a lot of the tax law stuff that you guys get into. We're looking at just specifically what comes here. And as I come look at this, I think there's some very valid points that need to be discussed here, but I don't know if it's in the scope of the commission to strictly do that. And as I started looking at this, discussing with legal counsel and other people, is we're very confined in what we're looking at. If I can pull discovery, if I can pull other things, I think it would be a much different thing, but we're not doing that for every single tax exemption. And then are we arbitrary and capricious by just mandating that one person give us all this information and documentation and all this stuff? Some people would say yes, some people would say no, other people would sue us. Do you see my point that I'm getting at here, is that I'm looking at just specifically what's in the brief. I think there are very valid points that have been raised here today that need to be decided by probably a court of law. Because I have a feeling that whatever comes out of this is probably going to set precedents for the state of Idaho.
Right, I think you're right about that. And maybe you go to the Supreme Court, maybe somebody goes to the legislature and changes the statute.
I know the legislature's been trying to do this. Like there was a fight on the floor over this exact same thing. St. Al, St. Luke's, their nonprofit status, and they generate hundreds of millions of dollars in revenue a year, and they pay no tax at all because they hold a nonprofit status, and they're the only game in town. And so it comes back to, again, as the commission, as we look at this, the 3% rule, and then in that same status, and I read back over this like 5 times trying to make sure that, where are we at? In 602 it says charitable, benevolent, fraternal organizations. Are they a charitable organization? Benevolent organizations mean that they contribute to the good of men and women. The mission statement of the Health Trust is to provide for public health for the citizens and people of Bannock County. And so we're starting to have to try and define terms, and I don't know if I have the full capacity to be able to do that. And so, Mr. Chairman, that's where I would just, as I've answered my question, I'm sure you guys have.
Commissioner Howe?
Well, in my reading through it, and I'm not nearly as eloquent as Commissioner Tubby, I went through and I thought the same thing, that I think this is beyond the scope of what we're able to do, because I agree that whatever happens here would set precedent for the entire state, and I don't think we are qualified to do something like that. So I would, again, agree with Commissioner Tubby that this goes back to legal counsel or the courts for a decision, not necessarily us.
And I don't know, Mr. Chairman, may I just quickly address that? And I think those are valid points, and I would just of course, from my perspective, I think the precedent has been already set in these 3 recent cases. And I think just because of those 2 initial requirements under the statute, I think the statute makes it easy. It doesn't make it easy for charitable organizations necessarily, but for the courts, I think it makes it easy. The property must belong to a charitable organization, and we've discussed that a lot. But the other part of that is property used exclusively for the purpose which it was organized, or the purpose which the organization was organized, not for, the purpose for the property. And so, you get into that, well, were they organized to rent out property for, rental properties? And so, so that's, just the point I want to make there. So, and it's just, we have the statute to go by, and we have the Supreme Court cases to go by, and from all the nonprofit work that I've worked on, and of course with the Evangelical Lutheran Good Samaritan Society, like, you see these guys, and like, how are they not, like you say, charitable, benevolent? Why isn't this under the statute? Why doesn't that work? But the statute is what we have to go by, and that's all that the commissioners have to work with.
Well, and to answer back to your point, you said it, simple for the courts. While we are all learned individuals, I have a master's degree in public administration, state and local policy and governance, and I consider myself probably more attuned to some of these things than other people. There are things in this that I am not fully versed in, that I don't feel fully comfortable, because I am tasked with looking at your form, which we are requiring, and I have other cases as I went through the case books in the last couple of days that show different opinions, and I have 16 attorneys in one office and 23 in the other, and all of them will give us a different opinion on everything. I mean, they'll give you a different opinion of what color blue your suit is. And so, but that's what I'm saying, is when it comes back to me, as I look at it, I think that this is and it comes back to, I think this is our initial scope of what we're tasked to look at with the evidence, the prima facie evidence that's provided to us by the appellant meets the criteria. And to go into that and to dive into that and to do that, I believe that rests either with the State Board of Tax Appeals, which sets a lot of these rules, or it needs to go to the district court for a really in-depth analysis that does provide then precedents for us to go by that's a lot more clear.
Can I just, one short thing on that? I want to let you, but essentially you're making the determination one way or another. They're applying for the exemption, they have the burden of proof. You're deciding it. There's no kind of, I'm sorry, I mean, like, you're the elected commissioners. It's a tough job. I empathize with you, but you are deciding it one way or another. You are deciding that either that their application either qualifies or it doesn't on the record that they gave you. And so denying, like, we can't just give it to the courts. You got to make a decision on it.
So this is where it comes back to the preponderance of evidence. The preponderance of evidence that is placed upon in the short and the long forms was met initially by the Portnoy Health Trust. Right now, with the understanding and the ability to go through and try and piece together cases and not being a scholar of the law, I'm not sure that the preponderance of evidence is fit to say, no, you can't have this on all of these parcels. I don't know if every single parcel fits that. So from my perspective right now, the preponderance has not been met yet at this time, because I just don't think we can get into it. I don't think we have enough time for a court case to go through this, and I think it's much bigger than an hour-long conversation to try and figure out what all is going on here.
I'll tell you where I'm at. Everyone knows that this deal bothers me more than anything else we do. Telling people you don't have to pay taxes because you don't want it. That's what it comes down to me. And it bothers me every time we go through and sign them. And we have brought a lot of them to us, and they've had to present evidence. But I'm at the point right now that after listening to you, I want to have time to talk to my legal counsel. That's where I'm at. I think that we don't have to do it as a commission, and we can do it individually. However, council feels like we need to do it. So at this time, I'm not willing to make a decision. I want to talk to my counsel so that I have the advice that I need to have, because it's not an area that I'm deficient in. That's what I feel, unless you two have a different idea.
Well, and again, it comes back to, like I said, I think it's more than an hour-long conversation. I mean, you guys have raised some very, very valid points. And the points that you're raising also come outside of the scope of the short form which we're given. So I look at it like in a planning and zoning hearing. We review what is presented. We don't allow new evidence to come in. We just only look at that. So as I start peeling off some of these layers, which I think are very valid points, I don't have anything that necessarily disputes the fact that they don't make a profit. I don't have anything that disputes the fact that they're a charitable organization, because as charity as I read it and I'm interpreting it, and we're, like I said, we're all in that opinion, they're a charitable organization. They have a profit sharing that they're showing. It says in Idaho code they can have 3% of the property, 3% can be used for commercial stuff. Well, what is commercial? Does commercial dictate that they must make a profit? Does commercial dictate that they have to charge a certain rate? That they're not receiving federal or state grants? There's a myriad of questions that we start layering on that I still don't think that we can break into without having records, depositions, subpoena. I mean, we can subpoena people, but we have 8 days before the Board of Equalization is over. And that's what I'm getting back to, is I don't think that it fits right now that we have hit the point that I can say that, yeah, they're not, because then they'll just come back and appeal, and, well, what did you appeal on? Well, they've made a very good argument. And I don't feel that we have evidence yet, but I'm not saying that it wouldn't be found if it was actually in a longer hearing that, as you said, you were rushed to present this.
Yeah.
What would it actually mean to be able to present the full case?
Yeah, that's good. I think the one issue is that I don't think there's any dispute that Port of Health Trust does not own the hospital. And that's in there. I think you can look and you can see that. And maybe your counsel can talk about that. That's the one criteria that deals with the biggest one. It clearly doesn't own it. It owns it through 2 different properties, and does that qualify? So that's the simplest one that I don't think you'll find.
So the question though I have is, I've read the contract for that hospital, and it says, from my understanding, that they're 23% ownership of the hospital. I mean, that's the question that I have then, and maybe I'm misinterpreting how I read that, but, you know, I don't know, do you guys have the contract to be able to say otherwise?
We have their applications. They say they're the 23% owner of Pocatello Health System LLC, and it's not the owner of the hospital. The assessors can tell you that the owner is Pocatello Hospital LLC. So the owner of the real property is, I think you can just ask them who owns the real property. They'll tell you Pocatello Hospital LLC. You can look at their applications, and it says that that's not Port of Health Trust.
Now I go back to what's been said.
Yeah.
And I want time to digest it and talk to my counsel. That's where I'm at.
And we really appreciate your time. Like, we know this is a tough job. Thank you.
No, I concur with Ernie.
Yep.
I have big heartburn going through that this year, approving all these, because same thing. So if we can have some time to visit with council and see, I'm very willing to do that.
Okay.
Thank you.
We'll
Thank
move forward
you.
with that.
We appreciate your
Thank
time
you,
and
gentlemen.
your consideration. I know it's a big fight. It is a
Thank
big
you.
issue. So thank you.
Recess.
Thank you.